An executor of an estate has many duties and responsibilities, and sometimes they fail to live up to them. Fortunately, California law allows for the removal of an incompetent or unethical executor under certain circumstances. These cases are more common than you might think, especially in high net worth states like California. If an executor abuses his or her power or appears negligent or reckless in managing estate assets, it may be necessary to file a petition for their removal in probate court. What is an executor of an estate or an administrator of a will? An executor of an estate or an administrator of a will, sometimes called a personal representative, is responsible for legitimizing and stewarding an individual's will through probate court after they die. The executor or administrator is generally chosen by the will's creator and is named within the will document itself. Executors and administrators are usually close family members or friends of the decedent. Parents often select their most responsible child for this role because an executor or administrator must be able to handle a great many tasks in a timely and precise manner. They must initiate and manage the legal process of probate, pay any taxes and debts due from the estate, distribute assets and property to beneficiaries, sell off assets as required, and many, many more things. Note that an executor can also be a beneficiary, and usually is. In most cases, this doesn't cause any problems, but in some cases, an executor who's also a beneficiary may act more for their interest than for the interests of the other beneficiaries. If you suspect this is the case, you need to consult a probate litigation attorney. Can you remove an executor? Yes, you can remove an executor under certain circumstances. The California Probate Code, Section 8502, allows for the removal of an executor or administrator when 1. They've wasted, embezzled, mismanaged, or committed a fraud on the estate, or they're about to do so. 2. They're simply incapable, incompetent, or otherwise unqualified to carry out their duties. 3. They've wrongfully neglected the estate or have long neglected to perform the acts related to its management. 4. The removal of an executor or administrator is otherwise deemed necessary to protect the estate. 5. For violating state laws. California has fairly liberal and broad laws governing the removal of an executor. It's important to note that interested parties can petition to remove an executor even before they've taken wrongful or ill-advised action. This is why it's always in a beneficiary's best interest to consult a good estate litigator sooner rather than later. In many cases, damage can be prevented well before it's done. How much does it cost to remove an executor? This depends entirely upon your specific case and the facts of that case. You can and should get a more detailed estimate through a free consultation with a probate litigation lawyer. Don't be afraid to specifically ask your attorney about their strategy and how they're going to keep costs down. An experienced estate litigation attorney will know how to proactively stop an executor from drawing out the process in an attempt to rack up attorney's fees and costs. At RMO, we always try to create opportunities for clients to have decision points to get results sooner and for less legal spend. What that often means is creating leverage to settle cases out of court, either through mediation or negotiated settlement. Doing that saves time, money, and stress. And while an executor usually recovers their attorney's fees from the estate if they win, the threat of potentially having to pay fees out of pocket and potentially your fees if they lose is often enough to bring them to the bargaining table. If you succeed in removing an executor, the court will decide if your lawsuit benefited the estate or not. If it did, then your attorney's fees often will be paid from the estate, and sometimes even by the removed executor. Do I petition to remove an executor? A petition to remove an executor or an application to remove an executor is a legal motion filed with a probate court on behalf of any interested party to a will or an estate. A petition for removal alleges that the current executor is unfit for their position due to negligence, misconduct, lack of ability, etc. The petition for removal is often filed alongside a petition for a replacement executor. Once the petition for removal is filed, the negotiation process can begin. Ideally, an out-of-court settlement can be reached between the parties with the assistance of their attorneys. At RMO, we've done a really good job over the years of securing significant settlements for our clients, specifically in these cases. make sure your lawyer does too. If your case does continue through court, the parties to the suit will likely be required to attend, and all other interested parties may be invited to testify as well. Once the court reviews the evidence and the judge decides if the executor should be removed, they'll order the removal and appoint a replacement. Keep in mind that the removal of an unfit executor does not protect him or her from further civil liability. If the executor did harm to the estate or its beneficiaries, the replacement executor likely may be required to pursue additional litigation against them to get back what was lost. What is a motion to remove an executor? A motion to remove an executor is a legal document filed in probate court by an interested party who believes that the executor is acting in a manner that is unlawful, unethical, or negligent enough to justify their removal. An estate litigation attorney will help you draft your motion, help you gather all the evidence, and put together a winning case. How do I remove an executor? To remove an executor in California, you should first consult with the best probate litigation attorney you can find. Usually the consultation's free. After that consultation, you should know whether you have a good case, how likely you are to prevail, and roughly what the cost could be. If you decide to proceed, your state lawyer will file a petition or motion to remove the executor, and from there you may either reach an out-of-court settlement or proceed to hearing. The judge will review the evidence and decide whether the executor should be removed, and if the judge grants the petition, a new executor will be put in place. Can an executor remove a beneficiary? Generally speaking, no. Except in the rarest of cases involving special and sometimes unenforceable provisions, an executor cannot remove a beneficiary from a will. To the contrary, an executor is directly answerable to the beneficiaries. As a fiduciary, executors are legally obligated to place the interests of the estate and its beneficiaries above their own. Removing a beneficiary from a will obviously is not in the best interest of that beneficiary, and any executor claiming to have that power should be treated with suspicion. Can you replace an executor? Yes. If an executor is removed either voluntarily or by motion, the courts will appoint a new executor to serve in their place. If the party who sought removal also files a petition to name a replacement, the court may grant that motion as well and put that person in place. Sometimes the person petitioning for removal is the same person who's appointed as the new executor. Other times, a nominated third party, usually a professional fiduciary, serves as the successor. The court will review all potential and willing candidates and appoint the person judged to be most competent. That person may be someone other than someone nominated. It may be a private professional fiduciary. The courts like private professional fiduciaries, neutrals, because they are not affiliated with any side. When should I contact a probate litigation attorney? You should contact a probate litigation attorney the moment you suspect an executor is acting against the estate's best interests. We cannot stress enough that it's best to act now rather than wait until resources have been squandered. Have questions? Shoot us an email, give us a call. Consultation's always free. Thanks for watching.